Dr. Aminu Adamu Bello, FICMC, a renowned conflict resolution specialist with vast experience in mediation and ADR practices. He is a principal at Bylaw and Bylaw, a member of the Chartered Institute of Arbitrator, a member of the American Bar Association, and also the fellow of the Institute of Chartered Mediators and Conciliators. He is known for his unique philosophy of resolution through resonance and not rigidity. So before we dive into this discussion, I would like to encourage us to fully participate, ask questions, share your thoughts. But before I hand over to him, please, if your microphone is not muted, please mute your mic so that we can avoid disturbance or interference from any device. If your location allows you to turn on your video, we encourage you to do that. And if not, you can off your video. Without further ado, I would like to hand over to our speaker, Your Excellency, Dr. Aminu Adamu. You're welcome, sir. Over to you, sir.
Thank you very much. Thank you very much indeed. Good afternoon, everyone. This is a rare privilege. And well, normal introductions suffice. And like it has already been indicated, I am a real villager. And so it's likely that my connection may be going off and on. So I would love that you bear with me and stay connected as much as possible. This is a great opportunity, in fact, to talk with people who are interested in alternative dispute resolution. We pride ourselves in saying ADR is not actually alternative, but it is African dispute resolution. I'll attempt to give you some insight into why we do not say alternative in our practice, but we say is African dispute resolution. I'll be taking some instances from people who have studied processes of dispute resolution, including litigation. And if there are lawyers here, I expect that your interest in joining this webinar is to hear things that will make you, or that will convince you to see other processes as viable means of resolving disputes, especially commercial disputes, other than staying in court for long periods. So good afternoon. My talk today is on the recently promulgated, using military terms, recent enacted Arbitration and Mediation Act. Because it is a dual instrument, I'll take a few minutes to give you a quick rundown on some of the new things that the Arbitration and Mediation Act has done to our legal system. Recall that before now, since 1988, we've had the Arbitration and Conciliation Act. Now, this present act, Arbitration and Mediation Act 2023, repeals that act. In the present act, one area that has been made so pronounced is the enforceability of mediation settlement agreements. Previously, there was no law in Nigeria that gave the powers to any court to enforce what is called MSA, mediation settlement agreement. But now we have it. It is in this act. Then the issue of communication. Before now, the existing act did not countenance electronic communication. Now it is part of the Arbitration and Mediation Act. Electronic communication is seen as communication and is admissible. Just like the Evidence Act has made it admissible, the act now has been upgraded, as it were, to include the admissibility of electronic communication. One interesting aspect of the new act is that it allows practitioners to source for fund from third parties. Now you wonder, why should a third party be interested in funding? And the question could be asked, why should a bank be interested in someone's business? It's also business. So the act allows a third party funding opportunity so that when parties think that, say they don't have money, somebody could venture based on agreement to finance the process of arbitration or the process of mediation. under the Act. Also, the new Act allows the appointment of emergency arbitrator. In a situation where before the Arbitration Act kicks in, a party or both parties may ask a court to grant them the opportunity to appoint, or the court to appoint, an emergency arbitrator. This gentleman, this party, will not be the arbitrator per se, but for the purpose of maintaining the status of the parties before they go into the full implementation of their arbitration clause, an emergency arbitrator will be appointed. They are also, following from this, the Act also allows for some interim measures to be implemented. The tribunal can grant interim measures during the arbitration process, even if it has started already. That is in the current Act. I'm talking about the arbitration aspect, so that I draw attention to the implication of putting mediation and arbitration in the same document. Now, the award review mechanism for arbitration has also been introduced in the present Act. What this means is that instead of going to court to set aside an arbitral award, parties could begin to seek ways of reviewing an award once it has been allowed, including even the process that led to the award. So this is also in the Act. You can also get more than one party to be part of the arbitration process. So the consolidation and joinder of parties is allowed by the present Act. Interestingly, it re-emphasizes the international mandate of arbitration in Nigeria. Now, on that note, you will recall that one of the interesting aspects of Nigeria's political aspiration is to resolve international disputes through ADRA processes, including arbitration and mediation. Today, the Arbitration and Mediation Act provides two sections. One of them is the one I've just mentioned. The other one is part 2 of the Act, which exclusively provides 20 sections. In those 20 sections, from sections 67 to 87, is talking about mediation. I do believe if Joshua is close by, maybe I can now run the slides. Then we'll speak to the slides and see how far we can go. But to be clear, before the Act of 2023, mediators in Nigeria have used the second part of the Arbitration and Conciliation Act as a signpost for conducting mediation. The conciliation part of the repealed Arbitration and Conciliation Act gave impetus to what we used to refer to as mediation. And if we look at the definition of mediation in the current Act, it is so interesting that what happens is that it defines mediation. It defines mediation as a means of resolving dispute, no matter how it is defined. No matter how it is defined. So, what does that mean? It means you can choose to define mediation as conciliation, but if you dare use a definition that borders on the idea of arbitration, then you are going back to the first part of the Act. I'm going staccato, forgive me, because I'm trying to get my system to accept to share the screen with the slide. Joshua, are you there?
Yes,
Joshua,
you can share your slide, sir.
You have?
Yes, you can share, sir.
I can share from here, right? Okay.
Yes, you can share, sir.
Okay. taking too long. Can you share from your end? Do you have access to the slides that I gave you? Hello, Joshua? Joshua?
Yes, I can share from my hand, sir.
Please do. Please do that. Please share from your end and let me see how it goes. So if you define mediation as a third-party intervention process that involves someone who is not a party to, thank you very much, who is not a party to the dispute as a neutral, it means that you have defined a means of doing mediation under this act. The definition can refer to a process, no matter how it's referred, where whether parties request a third person to assist them in the attempt to reach an amicable settlement of their dispute, arising out of a related or contractual or other legal relationship without imposing a settlement to the dispute. This is how the Act has defined mediation. In practice, and as per the training of the Institute of Chartered Mediators and Conciliators, mediation is thoroughly defined as a process that involves the appointment of a third-party neutral who now assists the parties refine their communication arising from either misunderstanding or misrepresentation within the context of a dispute. The dispute is not specified, any kind of dispute. So that now this third party will assist them to communicate, and in their communication, he now assists them to understand themselves and then reach their own settlement. As you will come to see, the Act deviates slightly from this definition. Like I said, it is a process, however referred, where parties request a third person, the mediator, to assist them in the attempts to reach an amicable settlement of their dispute, which will have arisen out of or related to a contractual or other legal relationship without imposing a settlement of the dispute. In this situation then, the Act, Joshua, next slide. Are you there? Hello, Joshua. The scope of the part 2 of the Arbitration and Mediation Act is applicable to international commercial mediation. It is also applicable to domestic commercial mediation. It's also applicable to domestic civil mediation. It's applicable to domestic and international mediation settlement agreements. Now, what's the difference between these three? International commercial arbitration is defined as a commercial relationship between parties who are not resident in the same country. It means it is mediation in commercial transactions between individuals who conduct their relationship across sovereign borders. So international commercial arbitration involves the buying and selling, the issues of maritime, the issues, as long as they are issues that verge on commercial transactions, issues where parties are willing to exchange goods and services and give money's worth. So if disputes arise within this context, it's termed as international commercial mediation. Domestic commercial mediation is a mediation of dispute between parties who are resident in the same country. In our situation, commercial transaction conducted within Nigeria, say between people who are living in the same state or people who are living in different parts of the country, but they are resident and doing business within Nigeria. Then there's domestic civil mediation. Domestic civil mediation refers to our normal civil issues. It could be matrimonial causes, it could be landlord-tenant, it could be those issues that involves individuals in their independent capacity as citizens of the country who are engaged in personal or interpersonal relationships, and these relationships hit rough waters, and there's a possibility of securing relief, they are allowed to use the content of the Arbitration and Mediation Act 2023 to resolve their dispute. When it is domestic and international mediation settlement agreement, it is now the agreement that is an issue. The scope of the present act allows Nigerian courts or parties to an agreement to seek the appropriate means of enforcing the agreement. Now we'll come to see how the enforcement process takes place. But the act now allows parties to seek enforcement of international mediation settlement agreements. This scope is very, very wide, and there's virtually nothing that will not fit into it. The only thing that becomes an issue is when there are policy considerations. And the idea of policy considerations brings into play those feelings of the particular country, in our own case, our own country, Nigeria, where in fact, if the issue is against public policy, and you should remember that public policy is an aspiration, what Nigeria wants to happen. If Nigeria does not want that to happen as a country, it is not its own aspiration, then the law will not allow it to take place. Then it will not fall under the scope of this act. I'll repeat that. When a policy issue is in place and the policy is against the aspiration of Nigeria, that matter will not be enforced within the shores of Nigeria. So that is the only exceptions that were in the issue of domestic and international mediation settlement agreements that is within the scope of the current Arbitration and Mediation Act 2023. So let me have the next slide. Joshua, if you're there, are we together?
Yes, my network was a bit bad earlier.
Sorry? Is it possible for me to take over control of the slide?
Proceed, sir.
Is it possible? Joshua?
Sir?
Can I take over control of the
I'm with
slide?
you, sir.
Can I take control of the slide?
Okay, that'll be fine.
Is it possible?
Okay. Okay, yes, you can share your slide. You can share the slide from your end, sir.
Okay. Let me crave your endurance, please. Give me a few minutes. Let me get this slide here so that I can take care of it myself. Just give me a minute, please.
Okay, sir.
Now, is my screen sharing? Is it shared, please?
Yes, sir.
It's shared, right?
Yes, sir.
Okay.
Yes, sir.
So.
Yes, sir.
Okay, thank you. Okay. So,
Doctor, resume your slideshow. Resume your slideshow.
I should do what?
Resume slideshow. Click it.
Okay, yes, resume slideshow. Thank you. Okay. So here we are. Now.
You are good to go now.
Okay, good. So what we have now is that in international mediation, commercial mediation, the current vogue is to align the process of enforcement with the Singapore Convention. Now, the Singapore Convention was established.
We are not seeing the slide. We are not seeing the slide properly.
You're not seeing the slide.
Your picture is covering the slide. Yes, your picture is covering the slide.
Okay, sorry. Let me get my picture up there then.
It's okay now. It's okay.
Is it okay now?
You can proceed now, sir. Now your video is up.
Okay, so I'm taking
it's
my
okay
video.
now.
It's still not okay.
It's okay now?
It's still not okay, sir.
Still not okay. Now you see
Not
how
completely. His name is there, but
your name is covering the
yes. But
okay. You'll have to forgive this non-millennials. For us, these technical things are not easy. So let me get let me be sure that. What about now?
Your name is still showing on the slide, but we can continue.
The name is still showing.
Yeah.
Yes,
you
but we
can continue, sir.
continue.
You can continue.
You can continue.
We'll share the slide to all participants after
You can continue, sir.
Okay, okay. So now, this Singapore Convention was established as a regime for direct enforceability of settlement agreements resulting from mediation. It is a convention that is multilateral. So many countries have signed onto it. And by signing onto it, I mean they have agreed that it be part of their laws, and they are using it to draft laws within the country to ensure that it abides by what other countries will also do. So it's a kind of reciprocal thing. It happened recently. By 2023, quite a number of countries have already signed onto it. And in fact, they have ratified it, as it were. So 56 countries, including Nigeria, have signed to the convention by September 2023. 11 countries have ratified the convention so far. Ratification has the effect of saying that now this is a treaty. And it means that because it's a treaty, the government of that country that has ratified it is obliged to ensure that the content of that treaty is obeyed by the courts of that country. And the implication is this, that the present Arbitration and Mediation Act will have to answer to requests by any foreign body that avails itself of the content of the act in the issues of international commercial mediation. If there is a clause or there is an independent agreement that this particular issue should go to mediation, then Nigeria is obliged to ensure that that happens. Now, under the present Act 2023, the way a mediation is commenced is by an offer and invitation to mediate by one party in writing to the other, stating the issues in dispute. And then there must be acceptance for the mediation to commence. When there's no acceptance, there's no mediation. and this acceptance by law has to happen within 30 days. The legal regime now means that instead of just waiting for a neutral to offer to assist you, your agreement, your contract would have to suggest, or in fact indicate, that we will not commence this particular mediation, which is one ADI method we want to use to resolve any matter arising from our interactions, unless one of us tells the other in writing that I want us to go to mediation. And then the other party now will accept. If the other party does not accept, then mediation will not occur. But if the other party also does not accept, or accepts after 31 days, it is possible that it is reneging. It is saying that I am not interested in mediation. By the way, this is a direct coding of what mediation entails. Mediation is voluntary. You cannot force any party to come into mediation. If the two parties in dispute do not agree, a mediator has no place as an intervention agent. When the parties agree that they are willing to submit to mediation, then there is a possibility that they are willing to speak for themselves and agree on terms. What the law has done is to place a time limit within which this invitation and acceptance will happen. It is 30 days from the date of invitation. Party A writes to Party B, I want us to go to mediation. Party B has to respond, accepting or rejecting within 30 days. Once that happens, mediation can occur. Then we come to the number of mediators. Ordinarily, when we train mediators, we tell them that you have the option of choosing only one mediator, or two, or three. When it gets to two, it means you are asking the parties to be co-mediators, or you are asking them to sit as equals. When it goes to three, it means you have a reason for getting a third party who may not be in concert with the other two. In arbitration, you're aware that parties will indicate how the arbitrators are appointed. If it is one arbitrator, they will both agree on the single arbitrator. If there are two, each party will appoint his own arbitrator. When they become three, the two people that are appointed by Party A and Party B will not sit and appoint a third mediator without the input of parties. Same thing is happening with the law of mediation today, as codified in the Arbitration and Mediation Act. There may be 1, 2, or 3 mediators. Parties must reach an agreement on the number of mediators. Where there is more than one mediator, they act jointly. So they are equal mediators. There is no, as it were, a third person who will cheer, as in arbitration, who will now be the person that will run the process. All three, so to speak, when there are more than one, all of them are equals. This is the provision of the Act. So it is not going to be possible for you to assume that because you're a third mediator, you are now going to be a vote breaker, whatever that means. But you are not going to be a voice that will, if there are disagreement. And incidentally, mediation agreements are unlikely to create disagreements. We'll get to that. But you should know that if it is a mediation, I hold the view that no mediation ever fails. And it means parties are the ones who are in charge, and they will determine what is good for them. The implication being they are not likely to refuse to see options that will adopt as their terms of agreement. Then who appoints them? The appointing authority could be the parties themselves. Then it could be from recommendation of mediation provider. And then it could be just a mediation provider directly. Now, here's the catch. If the parties are appointing their own mediators, they could together sit and say, let's appoint only one person. But they could say, okay, you bring one person, I'll bring the other person, and they sit as two mediators. Do it jointly. That is appointment by parties themselves. It could be recommendation of a mediation provider. The Arbitration and Mediation Act 2023 provides for the possibility of mediation service providers. Institutions like the Institute of Chartered mediators and conciliators are mediation service providers. There could be independent companies who also run mediation services. They are, for the purpose of this act, mediation service providers. And parties could approach a mediation service provider to now appoint a mediator or mediators for them. You should remember that this act only provides rules and guidelines for conducting mediation. It does not say that this is how the content of mediation should be. So if parties decide to approach a mediation service provider, the mediation service provider has a duty to recommend mediators who most likely would go with the orientation, the philosophy of that mediation service provider. Now the parties now have sought recommendation. Then it's possible for a court to refer mediation to a service provider. Now, once the court refers mediation to service provider, the service provider now can appoint a mediator directly. This is what happens, in fact, in court-connected mediation services. When the court says, go to a multi-door courthouse, it is saying the multi-door courthouse is a service provider. So now go to the multi-door courthouse. The head of the multi-door courthouse now decides who should mediate that particular case. That is the point of appointing authority vested in the mediation service provider. So these three processes are the three means through which parties could get to mediation and who appoints the mediators for them. This is the catch area where most practitioners are interested in knowing how they make money. So when you go to mediation, you should be aware that parties are obliged to bear their own costs and fees of the mediator, as well as the mediation provider in equal shares. This is the first requirement of the Act, that is 50-50. Party A will pay 50%, Party B will pay 50%. I may get the questions later, then how do you charge if you are doing ad hoc mediation or you are an independent service provider? We'll come to that. But once the charge has been indicated, that it should be before the commencement of mediation, the parties are obliged to bear the cost 50-50. If it's 10 million, each party will pay 5 million. If it's 1 million, each party will pay 500,000. Or the parties may vary the provision of the Act in relation to fees. Varying means how we agree. I'll pay 80%, you pay 20%. Depending on how much they are attached to the subject matter of the dispute. Some people would prefer to spend money paying mediators than waste money arguing about how to deal with the dispute. And once you get those kind of issues, you can be rest assured that the parties will agree to vary the provision of the Act. The idea being, the Act does not say that this is the only way to get payment for mediation services. It simply says that 50-50 in the first instance, or parties may vary the provision of the Act in relation to fees. And if they do that, it is their own entitlement. And once it is in writing, it's an agreement. A mediator is entitled to a fee and reimbursement of expenses incurred in connection with mediation, unless the parties vary that agreement. If the mediator says, I need my fee and any other cost I incur, incurring costs will now imply a reimbursement. But parties could say, no, give us the bill and we'll pay. So which means he will not be incurring expenses, in which case he will not be asking for reimbursement. Bottom line is, the mediator is entitled to a fee. So if you have been worrying about how to get into mediation and how you make your money, and if you are, I believe there are lawyers here, if you are one of the lawyers who thinks that ADR means alarming drop in revenue, I'll say that again, if it means alarming drop in revenue, don't be frightened. You are entitled to a fee, especially in situations where the court refers these matters to you. And under the Act, you should be assured that you are dealing with commercial mediation of international commercial disputes, also domestic disputes. In the rare instances where, as an individual, parties enter your office and say they want your intervention, you're doing domestic civil mediation. and that is also allowed. You have to design a way of charging for your services, so that is allowed. Now, in the process of mediation, communication between mediators and the parties is that mediator is required to meet the parties jointly or separately. Jointly in session means both parties are present. Separately would be when the mediation has started and the mediator wants to meet them separately in caucus during the pendency of the matter. Otherwise, it's also a process where a party A is in one part of the world and party B is in another part of the world, different continents as well, even. It's possible for mediation to take place. That is meeting them separately. It happens in arbitration. It also could happen in mediation. The bottom line simply being that he will have to meet them and he will have to design a way that he can most likely at a certain point bring them together. And this is where electronic communication comes in. Today, I'm talking with you. There are over almost 100 participants on this webinar, but we are not in the same place. I'm in my village and you are in your own place too. I'm in my office in the village, you are also probably in your office or at home. But it shows that we can communicate. The present act, like our amended Evidence Act, allows electronic communication to be accepted in evidence. And in the context of mediation, electronic communication is a viable and acceptable means of meeting parties in a dispute. I'll repeat that. Electronic communication includes this one that we're doing now. This is on Zoom. It's possible that an email will suffice. It's possible that a voicemail will suffice. The requirements are there in the Evidence Act and it's applicable to mediation. Once these requirements are met, then the law, our law, allows that those processes can be used to facilitate mediation between parties under the Act. Confidentiality. All matters are confidential, including the settlement. Disclosure is only allowed for the purpose of enforcement or implementation or stopping the commission of a crime. On this count, many a lawyer will wonder why even the agreement is confidential. If it is confidential, how can it be enforced? Now, the confidentiality in mediation is to allow parties to talk freely. If parties are afraid that what they say in mediation will be used against them, it's very, very unlikely that they will speak up. And the idea of mediation is to create an atmosphere for effective communication. Active listening is involved. So if parties are not able to hear themselves and appreciate what they say and understand themselves and reach settlement, then the mediation is of no use. So it is confidential because parties know that nothing they say in mediation will be used against them. Our courts have always upheld the idea of confidentiality in settlements, out of court settlements, because once it is settled, the courts will enforce it. But if it is properly settled, and this is my opinion, it is not likely going to the court, because parties would have agreed, signed the agreement, and the agreement will now be self-enforcing, because parties now will do what they have said they will do. In that situation, you don't have an issue. But what happens then if you have an issue? It becomes a matter of fact that the court, which is a means of enforcement, will have to see the agreement. And once that agreement is seen by the court, technically, the court now will cause it to be enforced because it is going to be looked at as an agreement between parties. This is what you have agreed. And there has to be a justifiable, a legal reason that's justified for you to renege or refuse to enforce an agreement that you are party to. The parties may draw up a settlement agreement by themselves. Mediators may suggest and draft a settlement agreement if parties agree. Mediators cannot impose settlement of parties. On this count, the present act goes one step outside the traditional realm of mediation. Yes, the parties, as in conciliation, the parties may draw up a settlement agreement by themselves in any mediation. A mediator may suggest and draft a settlement agreement if parties agree. May suggest. He could suggest and parties may draw up a settlement agreement themselves. He could suggest and then be the one to draft a settlement agreement if the parties agree. And this is the one step outside of traditional mediation way that I've indicated. Ordinarily, a mediator has no opinion in the process of settlement. The work of the mediator is to facilitate settlement, to work with parties for them to reach their own settlement, to agree on the best options that will solve their matter. This is the traditional approach. What the Act has coded is that a mediator himself can suggest, and that is legal, to suggest solutions. And remember the definition of mediation under this Act. It says conciliation, mediation, or whatever name it's right at. So long as it involves a third party who now intervenes between the parties to reach a settlement. It means here that this mediator is not a mere mediator. By the force of law, he has been assigned a responsibility. The force of law has now made him someone who should know, one, the subject matter of mediation, to know it very well, even if it's a technical thing, to know it, and to also know the law surrounding that particular subject matter. In which case, once he has the ability or has the power to suggest, it means he knows what the court may do if the matter goes to court. That power means he has to perform his function in a particular way. He will have to facilitate the process and also have the power to instigate, to stimulate, to push parties towards a particular outcome that he thinks is most viable. Except that the Act says the mediator cannot impose settlement on parties. The imposition is what the Act says mediator cannot do, but it allows the mediator to suggest viable options and in fact state, as the conciliator used to do, to say this is most likely the best option for you because the court is likely to treat this matter this way or that way or this way. In this situation, the mediator under the Act in Nigeria is an evaluative mediator. Let me explain. There are 4 models of mediation I'm aware of. One is the traditional, 2 broad types, in fact, the transactional mediators and the psychological mediators. The transactional mediators use facilitation and evaluation. Facilitation is the bedrock of mediation. It means you are a process manager. What you do is to get parties to talk to themselves, work their issues out, and you deal with them as possible as they really want to reach their own conclusion. It's their own conclusion. So you only facilitate. You become an evaluative mediator if, for instance, I promise you, you are in the multi-door courthouse because the matter has already entered the litigation stream. You should be aware that litigation is also an ADR process. It's an alternative to the other processes. So it has already entered the litigation stream. And the court now says, go to mediation. So now you have the case file, you have the facts of the case, and most likely you have lawyers representing parties. Good, they sit down. Remember, the lawyers will be advocating for their clients. What the mediator now does is attempt to look at the issues as the judge, the regular court will do it, but with a slight difference. Cannot impose a settlement. He can suggest a settlement, but he cannot impose a settlement the way a court will give a judgment. In this, under this Act, we have beginnings of a process of developing evaluative mediation within our territorial jurisdiction. There is third and fourth process. The other process is narrative mediation. Narrative mediation and transformative mediation are two systems that are not transactional, as it were. They're emotional. So it's likely that what you'll be thinking of is doing matrimonial courses, and in which case you are going to most likely fall into these two categories. Narrative mediation, your mediator want to listen to the parties and allow them to develop their own stories, alternative stories to the one they, or you want the parties to acknowledge each other and empower themselves so that they know where they stand and how they want to move from there. That's transformation. I mentioned 4: facilitation, evaluation, narrative, and transformative mediation processes. This present act, the Arbitration and Mediation Act 2023, provides the seed for the development of evaluative mediation, and it reinforces the powers which the multi-door courthouses across the country have. So if a mediator suggests a particular suggestion, he is availing himself of the role of a mediator under the Act. And it's not a disputable fact, because if the mediation is carried on based on the content of the Act, that is what is most likely going to happen. Remember this anyway, that parties could draw their settlement, a mediator could suggest and draft it, but a mediator cannot impose settlement on the parties. Now, it has been done. Parties have come to mediation. They have invited themselves and they agreed. They've sat down with the mediator and they've talked, and they have reached a settlement agreement. It's possible they may not reach a settlement agreement, but simply means that there are places, steps in the process where a mediation proceeding can be terminated. Mediation ends when the settlement agreement is signed. That is the end of a mediation, once the settlement agreement is signed. This is what the Act says. In mediation training, we carry this a little bit further and say, yes, once an agreement has been signed, yes, the settlement has been signed, yes, the mediator has done his job. No, we say to give teeth and to ensure that people feel and accept the benefit of mediation, the mediator is obliged to follow up post-settlement contact, to speak up and contact the parties. How are they faring? Because it's possible that something could happen after the agreement has been signed, and one party could draw back and say he has misgivings. So the mediator is obliged, as it were, to see that parties stay in the agreement and ensure that it is enforced. They enforce the agreement. So as far as ICMC is concerned, and it's my own opinion too, that mediation does not simply end on the signing of the agreement. Mediation ends when every part of the settlement agreement has been implemented and people are happy. And this is when you realize that it's a win-win situation. Also, a mediation can be terminated where the mediator declares that there is no need to continue the mediation. How can that happen? A mediator could be frustrated and he has done everything he can to move the process forward, and he has failed. He has done all he can and he has failed. And the Act allows the mediator to declare that this mediation cannot continue. If it's a court-referred mediation and multi-door courthouse, by making that statement, it means you're asking the court to take over and finalize. So it's no longer an issue for mediation. It could be terminated where the parties declare that mediation should end. Parties could, on their own, decide, oh, well, I think I'm tired. Even though we agree we're going to do this mediation, is enough. It could arise from bad faith. It could arise from something else. But once the idea is that one party is not comfortable, you'll have to inform the other party that, look, I am not comfortable with this mediation any longer. So let us end it by informing the mediator. And then the mediator is informed the parties have agreed to end mediation. That is the end of the mediation. Hear this out. Mediation settlement agreements finalize mediation. But a mediator could declare that there's no need to continue the mediation based on his professional understanding and the difficulties he has seen or anticipates where the decision will not go forward. This could happen where he has tried to get the right parties to come and sit with him. What is getting the right parties? The parties who come to sit at mediation must be the ones who are able to bind parties to the agreement reached at mediation. If a company has sued another company and the court says go to mediation under this act, then one of the parties sends a regional officer who has no authority to bind the mother company of the continent. It's not possible to do mediation because now there will always be break. Let me consult with my principal. Let me consult with my principal. And that stalls the mediation. And if all efforts by the mediator to get the right person to the table does not succeed, the mediator is likely to say, look, this mediation cannot continue given these circumstances, and you send the matter back to the court, and the court will know what to do with it. But where the parties declare that mediation should end, they don't have to give any reason. It's their own matter, so why bother? But they will have to inform the mediator that we have agreed to suspend this mediation, and it ends, it terminates. That is the end of it. Where there's an agreement, a signed settlement agreement by parties and evidence that settlement is from mediation will be used. Ordinarily, sometimes we don't reduce settlement agreements to writing, but under the Act, you are required to reduce all settlement agreements under this Act in writing, signed by the parties, and call it a mediation settlement agreement. This will evidence an agreement which the court now will use for enforcement. I repeat, a mediator will now cause an agreement to be signed by the parties. This is entitled Mediation Settlement Agreement from mediation. The court will now use that instrument to enforce the content of that mediation. Also, a mediator or mediation provider would cause a document evidencing mediation to be produced. Now, I cited the example of ICMC earlier as a mediation provider. ICMC could be the one who will appoint a mediator, and the mediator will now report to ICMC after the mediation. Now, ICMC will now be the one that now writes and says this mediation has taken place, in which case now the court will be obliged to enforce the settlement contained in that document, or any other evidence acceptable to the court. What that will be will depend on the court system. In Nigeria, generally, it should be the agreement that will be signed by parties. And once that is signed, simply causes the agreement to be enforceable under existing law. It could be forced to be a contract. I use the word forced advisedly because once it is a contract between parties, it becomes enforceable between them, all the content of their agreement as a contract on pain of sanctions from the court. It could be the court now seeing the agreement and then entering it as a consent judgment or as a consent award. These are three processes that the court could use to enforce a settlement agreement under the Act. It's also possible, ladies and gentlemen, that the court system will refuse to enforce a mediation settlement agreement, and there are grounds for that. Some of the grounds are this: that a party was under some incapacity that renders the settlement agreement void, inoperative, or incapable of being performed. This is the usual jargon in contract. Once the party was under some incapacity, and defining incapacity is a legal thing, the courts have a way of looking at it. And lawyers know that there are ways of raising issues that will show that there is, in fact, an incapacity that renders a settlement agreement void. If there is coercion, where there is fraud, if all these things can be established, then the courts will refuse to enforce it. We are talking about international commercial mediation or domestic commercial mediation. And this things could happen. People could be blackmailed into signing a document. And once that can be established, the courts of our system will refuse to implement that agreement. Or the agreement is not binding or is not final according to its terms. How is that possible? It's possible that the parties have agreed in part and have not agreed in part. So it's not easy for a party to go and seek enforcement of the part that has been agreed and ignore the other part, unless they have said they could do that. If it's not possible to say they could do that, then the courts will not agree. There has to be a clear statement of fact that indicates what is expected in enforcement process for the court to allow something that is not binding or not finally finalized according to its terms to be enforced by any court system. Well, if the agreement is modified, once a party can show that that is not the agreement that we reached, something has happened to the content, the courts will not enforce it. The obligations in settlement agreement have been performed or are not clear or comprehensible. Again, legal reasoning will allow the courts to look at the agreement and reason according to the content of the agreement and see if the obligations in the agreement have already been performed or are not clear, or three things here are here. If the content have already been performed, then it means the agreement has already been executed. Why go to court again and seek settlement, seek enforcement? But if the contents are not clear, it means something is wrong. One party may be saying that I don't understand this and I need clarification. The courts will not enforce it. They'll be sending them back to the mediator and get them to clarify those issues, then come back for enforcement. Or where the content of the agreement is not comprehensible. And that would be a shame, because the idea of a mediator drafting the mediation settlement agreement is to ensure that it is clear and comprehensive, so that there will be no doubt. It requires clarity. It requires totality. It requires enough information that will allow the parties to know their obligations within the settlement agreement, which in fact is a contract between the parties. It could be refused also where granting relief will be contrary to the terms of the settlement agreement. If a party goes to seek relief that is not within the terms, the courts will not allow it. The Act specifies that that is a ground upon which relief will not be granted. Relief will be granted only according to the terms that have been settled and agreed by parties. Also, where there was a failure by the mediator to disclose to the parties circumstances that raise justifiable doubts as to the mediator's impartiality. Now, in the ICMC, we make a meal of saying that you must know how to make an opening statement. And in the process of making an opening statement, you must have to raise the fact that you are impartial and intend to be neutral. Impartiality is a function of neutrality. You are neutral if you do not have any connection with any of the parties. How is that possible? You will have to show, say for instance, one of the companies before you employs your daughter, and they have come before you, you are the mediator. You will have to disclose the information that your daughter works in the company being represented by mediation. And you'll have to ask the agreement of the parties whether you should continue. You will have to establish from the outset your neutrality. If one of the parties is comfortable with your relationship with the other party, you are obliged to recuse yourself, to ask them now to go to another mediator. But if the mediator is comfortable and says, well, there's no problem, that particular relationship will not affect your neutrality, then you are good to go. So if the situation is made known to the court that the mediator does not disclose a relevant fact that could justifiably be seen as an influence on him in support of one of the parties, courts are not likely going to enforce that settlement agreement. Now, ladies and gentlemen, I will take questions if you have any. Are we together? Joshua, my slide says questions. So what I've done is briefly look at the Arbitration and Mediation Act as it is at the moment, and what it entails, and the processes that's involved. So if you are there, and if you're going to coordinate the questions, I'll appreciate it. How about you, Joshua? Joshua, are you there? Ladies and gentlemen, any questions at this point, please? Any questions? Or is it that I've been talking to myself? I love the notion, is, as it were, that somebody will say it's too technical, and then we'll identify the technical area and see how we deal with it. Are we together? I see Professor Olajide. Professor, good afternoon. It's a pleasure. You are muted. You are muted. You are muted. You are muted. Unmute yourself, sir. I think you can unmute yourself. Your microphone is muted, sir. Your microphone is okay. Good.
Thank you.
Yes.
Thank you. We were not allowed to unmute ourselves before, but thank you.
Yes.
I thank you very much. This is very enlightening. You were not sitting the session, so I wasn't sure. The part I'm kind of interested in understanding is where you spoke to when how the court may treat cases of enforcement. You mentioned they could treat it as a contract. They could treat the settlement terms as a contract, as a consent judgment, as a consent award. Now, are there specific sections that speak to that in the law, or that's your interpretation of how the court may take it?
I wrote the slides from the content of the Act. So the provision of the Act, if you give me a minute, I'll get the specific reference.
Thank you.
It says that the court will enforce it as a contract between parties, a consent judgment, or consent award. That is the provision of the Arbitration and Mediation Act 2023. So it is in the Act. It's not my interpretation. Are you there, sir? Are you there? Your microphone is muted. Can we engage? It is in. Said it's in the Act, sir. It's not my interpretation.
Okay. Thank you. Thank you.
In the Act.
Yeah, I wasn't allowed to respond. Yeah, that's interesting. I would like to have to look at it because I'm just wondering if there's no lacuna there. Because if the law wants to say who could enforce, I would have thought they would leave it at that. But to say the court may take it as a contract, which is what it is anyway, as a consent judgment or as a consent award. Usually, what we know is that when an arbitration is ended, the award may be a consent award because the parties could have agreed to settle one or a few other parts of the arbitration amicably. Then to be the award would take that as a consent award. Or when we do mediation, at the end, the parties could agree that maybe the mediator wears the cap of an arbitrator to turn the settlement agreement into a consent award. And then for judgment, the parties could agree to take it to the mediation agreement settlement in court as a consent judgment. So where these situations don't exist in the sense that there are no independent document talking about a valid document or a consent award or a consent judgment, and the law expects the court to treat it as such. I wonder whether they're not creating a problem there. I would have thought the best thing is to just say, if we reach agreement, settlement agreement, the court should enforce it. And then they could look at those circumstances where maybe there should have been disclosure, policy, and all that. But this one that is put in the law, I think it might create problem for the court. Thank you, sir.
Yes. Incidentally, the section is section 82. It says, where parties conclude an agreement, settling a dispute, the mediator shall participate in the preparation and drafting of the agreement where the parties agree. And section 82.2, subject to section 87 of this act, the settlement agreement resulting from the mediation is binding on the parties and enforceable in court as a contract, consent judgment, or consent award. That is section 82, subsection 2 of the Arbitration and Mediation Act. So is the act, sir. It's possible that there's a lacuna, but that is a subject for another day. Are we together, sir?
Thank you very much.
Okay, you're welcome, sir. Helene Kalu, I see your hand up.
Yes, sir.
Yes.
Good day, sir.
Yes.
Thank you so very much for that insightful session.
Oh, we tried. Pleasure.
Yes, sir. I have about 3 questions.
Please.
The first is, I didn't clearly understand what you said about the number of mediators that the Act stipulates. Are you saying that one person cannot be a mediator? That it must be 2 or 3? And then if it must be 2, then who presides over the session? And then the third one is, you talked about the parties being in charge of the session. But we were taught that the process, the proceedings, is owned by the mediator, while the parties owns the case, the dispute. Okay. So I need clarification on this.
These are 2 questions, right? These are 2 questions, right?
3, sir.
3. Which is the third one?
I asked. The first is does the Act provide for only 2 or 3 mediators? Then, if that's the case, are you saying one person cannot be appointed a mediator? And then, if it must be 2, who presides over the session?
Presides. Okay.
Yes, sir. Thank you, sir.
You see, I said the Act has attempted to mimic facilitative mediation, where you could have joint mediation that is a co-mediator, or the other one we have a sole mediator. The provision of the Act is that there could be one mediator, there could be two mediators, or there could be three mediators, depending on the agreement of the parties. The parties will be the ones to agree that we will appoint only one mediator. And if they appoint one mediator, two of them will agree. Or they will ask a mediation service provider to appoint, or the reference body will appoint a mediator. And I even cited the example of the multi-door courthouse. What you are making reference to is the traditional system of mediation. And like I said, what the Act has done is to codify aspects of mediation. Some of the things in the code may not go exactly as we are used to doing in mediation. And that's my opinion too. The idea is you could have one mediator, you could have two mediators, you could have three mediators, but all of them are equal. There will be no presiding mediator. So they'll be doing a joint mediation. They will be doing it collaboratively, the three or any number of mediators that parties agree. It's not like arbitration, where if you have more than two, the two are appointed by either party, and a third is appointed by the arbitrators, so appointed by other parties. The idea of arbitration is to ensure that there's a third voice who now presides, where the other two who have been appointed by the parties now sit and then do the arbitration. In mediation, and I think I like this particular provision, that mediators are equal. There is no presiding mediator. And as a mediator, you know you have been doing co-mediation. And it doesn't mean that you are superior to the other person. It simply means that you are both mediators and you can move the process. Is that clear so far? So yes, there could be more than one mediator. I'm not saying there has to be only one. The Act allows parties to appoint more than one mediator. Secondly, there is no presiding mediator where you have more than one mediator. They are all equal. That's what the Act specifies. And that's the tradition of mediation, that you have equal powers within the mediation system. And you can now move the process, assisting each other to move a process, not processes, one process, facilitate the process for parties to resolve their matter. Then the idea of owning the process, the content of a dispute is not your own as a mediator. So you don't own it, you facilitate a process. The parties can opt out of it. And if you own it, you can oblige them to remain. But because they own it, they can feel uncomfortable and get themselves out. We don't encourage mediators to place it within the opening statement that this is voluntary and you can leave. Within the Act, the voluntariness ends at the point where you have agreed that you go to mediation. That simple agreement to mediate obliges you to attend to mediation. The voluntariness of mediation is when it is not within the context of a legal framework. The voluntariness of mediation is as a system that allows parties to avail themselves of the ability and capability of a neutral third person who will now assist them to resolve their dispute. Once it falls within a legal framework as enforceable within the courts of the jurisdiction, it means there has to be a legally sanctioned and acceptable process. So the Arbitration and Mediation Act 2023 says you can appoint one mediator, or two, or three. But where you appoint more than one mediator, all of them are equal. Then the system, the process means that you engage with it. The mediator moves the process, but he does not own the process. Does that answer your question?
Thank you
Yes,
very
sir.
much, sir.
Yes, sir.
Before
Thank
we
you
take
very much.
Dr. Ndubuisi, there's a question from the chat box.
Yes.
And Dr. Ndubuisi will be the last question we'll take. This is
Yes.
coming from Victoria So Mary.
Okay.
She's saying, thank you for the educative session. My question is, for the application of the Act in international commercial arbitration, in a contract negotiation / drafting where two parties are resident in two different countries, the Nigerian counterpart desires that arbitration is in accordance with the Arbitration and Mediation Act, while the foreign counterpart desired otherwise. How can these be addressed? What are the key points to be highlighted in convincing the foreign counterparts? Coming from Victoria.
Okay, that's interesting. But in fact, what you are aware that anyway, if you talk about arbitration, you're talking about a contract within a contract. Now, one interesting thing I find with this act is that it allows you to think of arbitration, but on a lighter mood. I say on a lighter mood because certain stringent measures that are within the act in connection to arbitration have been watered down for mediation. If two parties have a dispute, and if they were unable to draft an ADR clause within their documents, it means they have made a mistake. In international commercial transactions, most people would draft a clause. It says there's a system that we will follow to resolve our matter other than going to court. But where they do not do that, then it has to be a process of negotiation within the parties. What do we do? The question is, if the Nigerian business person wants to use the act, yes, we use the act. Remember, the ancestral model laws, the United Nations Commission on Trade and International Trade Law provides some model laws that countries have been using. Now the Singapore Convention has come on stream. It's very unlikely that any person worth his salt will draft a contract without thinking of the possibility of a dispute arising. Nobody wants a dispute to arise, and I make this joke all the time. Nobody wants to be sick, but there must be a hospital. Nobody wants a mortuary, but people will die, or cemetery. Nobody wants a police station, but there could be the conflict. The same.
So your mic is muted, sir. You may need to unmute.
You muted, who muted me then?
No, I don't know.
Oh, okay, sorry. So let me repeat that. In the unlikely event that a contract exists where parties did not put an ADR clause in their contract, then when a dispute arises from that contract, they are obliged now to talk to themselves without initiating legal proceedings. My colleagues will say, why not initiate legal proceedings and in Nigeria ask the court to allow you to go to do an ADR process? Because, and we're happy for that, because in Nigeria, almost all the rules of court have provision for recourse to ADR processes. Nigerian lawyers are aware of the rules of professional conduct for legal practitioners. The recent one is 2022 or 2023 that requires lawyers to tell their clients of the possibility of an ADR option. Direct answer to your question. In the unlikely event that parties did not insert a clause at the start of a dispute, they are likely to talk to themselves and go into that agreement to seek an outlet in the process other than litigation. Does that answer your question? Okay. Victoria,
yes.
Victoria smiling.
Can you hear me?
Yes.
Good afternoon, sir. Good afternoon, sir. This is Victoria. Thank you very much for the response.
Yes.
So I think there was a bit of a misunderstanding with the question. It wasn't. I wasn't painting a scenario of where the parties omit to draft an arbitration clause. I was trying to say before, like where two parties are about to enter into a business transaction, an international business transaction, and they have to draft a contract. And then in that contract, usually, I'm talking from now practical experience, and in that contract, they're about to draft an arbitration clause. Usually, that arbitration clause will state the rules that would guide, or the particular this thing that would, guide the arbitration process. So my question is, for a Nigerian company and say a foreign company that are negotiating on that to be able to come to an agreement on which particular rules to use. Most times we would prefer, as a Nigerian company resident in Nigeria, would prefer that we use the Arbitration and Mediation Act, understanding that the act was modeled after the ancestral listeners. So, but the foreign counterparts are usually very hesitant to agree to that. So I was saying, are there any like key points or highlights that you can use to convince them that the Arbitration and Mediation Act is standard for international transactions and is best suited for those kind of transactions? Because 98% of the time they're usually hesitant to use that. They'll rather use maybe English and Wales law or whatever, and all of that. So yes, that's my question. Thank you.
Okay. Unfortunately, the issue you've raised now is not the matter of the law itself. It is a matter of perception. And this is my interpretation of the situation. If, like I said, the ancestral model laws have been in use for a very long time, since the late 80s, and almost all members of the United Nations, member countries of the United Nations, have adopted parts of it, modified it into the arbitration laws. It's unlikely that a particular country will say, we will not use your law. Give them the law and let them look at it and then tell you their misgivings. They show you their misgivings. In which case, if they indicate their misgivings, you now show them how that is relevant and consistent with international law. That is the point. If they want to use their own era, the Nigerian Act also defines international commercial mediation. It says it's international when the parties are in the two different countries. But what law applies? You're talking about the law of the place, or the law of the law of the parties, or the law of the place of the business. If it is in Nigeria, you have no option. If the contract is done in Nigeria, they have no option. It's Nigerian law. So you don't give them the option. You show them the law. It's not for them to choose. It's for them to abide by once there's an agreement. That is the answer. That's the simple answer I can give. The issue you raised is not the matter of the law itself, the matter of perception. They'll be wondering, if you're using Nigerian law, you're thinking of the court system within Nigeria. And if you go to another country's court, you're thinking of interpreting Nigerian law in another country's court. That is a problem of perception. It will be left to you as a lawyer, I believe you're a lawyer, to now show the party that it is the law you are talking about, not the perception of people of the country. Does that answer your question?
Yes, sir. Yes, sir. I totally agree. Thank you.
Doctor.
Thank you.
Yes, sir. Hello? I can hear somebody's voice there.
You mentioned something. My name is Dr. Binga.
Yes, sir.
My name is Dr. Binga. If I may help.
Yes, sir.
You know, when there is the ADR clause,
yes,
you have the prerogative to indicate
yes
the law that you want to go by.
Yes.
For instance, if you are drafting an ADR clause in an international contract, then you have that choice to see that you are adopting the Arbitration and Mediation Act of Nigeria.
Yes.
Provided that party agrees to it, then that is enforceable.
Yes.
So I agree with you that it's about having a clause and the direction of that clause. What are the clause stipulates what to follow?
Yes. Yes. So, thank you very much for the assistance, sir. Thank you very much. Much obliged. That is the point.
Thank you, sir. So, Dr. NBC, you can unmute your mic, ma'am. Sorry.
Good afternoon, Dr. Bello.
Good afternoon, sir. Good afternoon, sir.
It was such an incisive lecture, and I enjoyed every bit of it. And
wow.
I want to congratulate you guys.
Thank you for the compliment.
Thank you so much, yes, because I learned quite a bit. But I need some clarity on an issue.
Yes.
I don't know that you normally have, maybe I wasn't here when you addressed it. The issue of, for instance, now when you talk about in arbitration, there are things that are considered not arbitrable.
Yes.
Do we have issues in mediation? And what does the Act say about it? That is one. Two,
yes.
When you were discussing the issue of confidentiality,
yes.
I think if my memory serves me right, I think there is, I think it's section 76 that says, that gives party the right to say, oh, to make it open if they want to. So because you said, maybe I didn't hear clearly, but you said
yes.
Everything has to be confidential and up to the agreement. It is only when the court has to enforce it, something like that, along those lines. But I'm not too sure, so that I don't quote you. But yes. I think that party have right to say, okay, no, we don't want to make this confidential because the law says unless otherwise agreed to by the parties, every information. Yeah. Yes. So please, if you could speak to those points, thank you.
So with the last one, and your understanding is correct. The parties could waive the confidentiality, but technically within mediation, I have held the view, and I've stated it often, that the concept of confidentiality, and the Nigerian courts have also upheld that position, that the idea of confidentiality is to allow the parties to speak freely in a settlement process out of court. They could say something within the process of settlement out of court, and that thing could be adverse to their interest. And while in a normal litigation process, something like that could be used against the party, in mediation, the law does not allow that to go. And in fact, existing precedents in Nigeria indicate that courts will not admit those as, make that admissible evidence. It can be objected to because it was said during parties' settlement process. Because if the courts will not use those information as evidence, then parties may not be willing to go and open up in a proceeding that is not before a magistrate or before a court, and then maybe open themselves up to certain setbacks. So yes, parties could, if they wish, but most likely I don't advise it, that they could waive the idea. And the Act says by agreement of parties, the parties could agree. Once they agree that it can be it could not be confidential, then it's their agreement. But if they don't have that agreement, the Arbitration and Conciliation Act says it has to be treated confidentially. Does that answer your questions?
Yes, sir. On the other issue that I raised, yes, of course, it does. The other issue that I raised, the issue of whether you have similar things or similar subject matters that are, I don't know how.
Yes. They are. It's in mediation is the issue of public policy. There are certain things that the authorities will say from time to time that it cannot be mediated, and that's according to law. As a mediator, I make the case that there's no issue that cannot be mediated, and people are wondering why I make that position. I said, look, even criminal cases can be mediated. So the question is, how can a criminal case be mediated when it has the ingredients and then including the punishment already stated? A party to a criminal act cannot choose to go to mediation. But I raised the point, I said, look, but there is a restorative justice, in which case the idea of ADR in this context is not about the crime, it's about the punishment. So where a country says, let's use Nigeria, when in Zamfara, a business that runs a hotel and sells alcohol outside of town, no matter what happens, the law of Zamfara will not see the issue impacting the sale of alcohol within city precincts as a matter that they can mediate. The state policy will put that out of contention for possible settlement out of court. It has to go to court because it's the state policy. The same thing in international commercial arbitration. There are certain goods that cannot come into your country. There are certain items, there are certain businesses that cannot be legally conducted within your country by force of state policy. And because that exists, those kind of areas are not likely going to come up in mediation under this act. That's my position on the question, sir. Does that answer your question? So it's akin to what is not arbitrable. You're talking about arbitrability. There are some items that may not be arbitrable based on, again, it's also issues of state policy. That's my answer, sir.
It's not, I'm not discussing arbitrability. I'm saying that just like you have it in arbitration, yes, whether there are issues that could not be mediated. Do you understand? Okay, so yes. I think you answered generally. It's just
okay.
Yes. Confused. Thank you so much.
You're welcome, sir. It's a pleasure. Another question, please. Another question, please.
No, there's no other question, sir. Thank you very much for that.
Okay, so I'm handing over to Joshua. Thank you for the opportunity. It's a pleasure.
Yes, yeah. Thank you. Thank you very much for that fantastic presentation, sir. I want to say a very big thank you to you. And to our participants, thank you for joining. We look forward to seeing you in the next webinar for the month of March. And if you care to know more about ICMC, you can visit our website at www.icmcng.org. So without further ado, I'd like to say a big thank you to everybody. Thank you and have a good afternoon.
Thank you so much. Thank you.
Thank
you, sir.
Thank you.
Thank you, Josh.
Thank you.
Thank you.
Thank you very much.
Thank you.